Let's bring in Advocate Romeo Nthambeleni to weigh in further. Advocate Romeo, good afternoon, and thank you for your time on the SABC at this hour.
Yeah, good afternoon to you and the viewers.
Perhaps for context sake, you could provide us with some context to this, leading up to this urgent application as we speak.
Yeah, look, the process of bringing urgent applications in court, and if you bring an urgent application that is not urgent, the court will dismiss your application. And if you bring an urgent application that the court determines that it's self-created agency, as the one that was brought by the EFF, the court dismisses it because the basis was that the papers were voluminous and they were bringing an urgent application together with the review to set aside the decision that was taken by Parliament. And at the end, the court could not actually go into the merits of the matter and dismissed the application on the basis of non-compliance with the rules and the practice directive of court. And that is why ultimately the application ended up being dismissed. Not saying that there was no merit in the application that the EFF was bringing, but the timing, which was the way the EFF brought that application, was not appreciated by the court, and the full bench ended up dismissing that application. 3 judges were sitting, and two were in agreement, and the dissenting judge was Judge Tulare in that matter.
Advocate Romeo, for those who are not privy to the new rules of the National Assembly regarding members of Parliament who disrupt President Cyril Ramaphosa whilst addressing Parliament, walk us through that and the objections that have been raised by the EFF then.
Yeah, look, the issues of the new rules of Parliament has been redrafted when this episode has been happening each and every year in the State of the Nation address. And I think what is important for the viewers to understand is that the Parliament is allowed to regulate its own processes, and that is what is done in terms of the Constitution and the separation of powers. And the court in this matter emphasized the fact that once you are under the rules of the court, you have the Parliament rules, as the EFF are, as members of Parliament, they are subjected to those rules. And if you create problems, you are creating self-created problems that the court will not be able to interfere. The only time when the court can interfere in the work of Parliament is when something that is unconstitutional is being done. And by Parliament implementing these new rules that you are referring to, that requires the order of Parliament and the processes in relation to how the State of the Nation is conducted. The court cannot interfere with that unless you demonstrate something that is unconstitutional that has been done in those rules. And the EFF has legitimately failed to do that in their papers.
Well, earlier this week, the same court dismissed another EFF urgent application to reverse the suspension of 6 of its members. Is this linked in any way? Or help us also understand that in relation to what's transpired yesterday.
Yeah, in the application, there were 2 applications that were brought. The other one is to review the decision which related to the docking of salaries of the members of the EFF through their conduct that was in Parliament. You are talking about that other judgment. So, they wanted that decision to be reviewed and set aside. And the court could not actually deal with that review as well, based on precisely what I've just indicated when we were making this discussion. Yes. The timing of the papers and the bringing of the applications together at the same time. So a review is a complete different process that has to be brought following the requirements of the rules of review, how the review has to actually be brought, and the must be basis of bringing that review in law and in court. So basically, it has not passed that threshold that the court actually required, and said, within the normal time, if they bring the application, the court can usually entertain it, but that will be after the processes of the State of the Nation address has already passed. The court can look at the review and find if ever there's substance in the review that is being brought by the EFF in relation to the salaries of their members and the 6 members that you have just referred to.
Let me wrap up. I wonder from your vantage point what impact or bearing this is going to have on SONA without the usual antics from the opposition party. And also if we're looking at possibilities and probabilities as judgment had been reserved. I mean, if successful, what are the implications? If not successful, what are the implications? Just as we wrap up.
Yeah, look, in terms of the SONA, it means that those members that have been suspended from Parliament cannot be in Parliament during SONA. So, obviously it's going to affect the proceedings of those members for their leaders not being there. And then the Parliament is saying that their rules must be followed as they prescribe, that if you are a member of Parliament and you have to conduct yourself in the manner that the parliamentary rules as revised must actually be followed. And then in terms of the talking of the salaries, later it is the decision is reviewed and set aside. It means that maybe the salaries issue can be resolved to say that the members cannot suffer double jeopardy of being absent from Parliament and also their salaries being docked. So that is the procedure and that is the processes which the court has to determine whether there's fairness in them insofar as that reservation of that judgment.